Welcome everybody to today's Talk with Doc. Today's topic is on how to prepare for your child to turn 18, a very important topic, and it's my honor to have Michael Jahn join us. He's an attorney, specializes with special needs trusts planning. So we're going to be talking through a lot of different things. Whether you're with us live on our Zoom or you're streaming with us on Facebook, we'd love to also get your questions as we're going through on Facebook. You can go ahead and put your questions on our chat here, and I'll take those on Facebook. I'll be following on Facebook as well. You can put them in the comments section, and we'll be getting those and get to your questions with everything. But want to thank everyone for joining. And again, Michael, thank you. And why don't you just tell a little bit about yourself and then let you go.
All right. I'm Michael Jahn. I'm the founder of KC Legacy Law, and I took a modern approach to estate planning. For a number of years, I noticed that the traditional model that I learned in law school and how most estate planners practice today really failed their clients in major ways. And I was really happy to find a smarter and a more personal method to help my clients. There we go. I graduated from the University of Kansas and the University of Detroit Law School in the 1990s. I passed the bar and became licensed to practice in Kansas in 1997. Since then, I've worked as an attorney for the Social Security Administration for a number of years. I founded a charity to help the homeless and first responders to disasters, and then founded 2 medical practices, complete with medical doctors and nurses. Then at the start of the pandemic, I met several other attorneys who practice this modern form of estate planning. We talked about the serious problems with the traditional cookie cutter approach to estate planning and the way that we were taught in law school. And even though I had done wills and trusts for family and friends over the years, I realized that traditional model left too many people down. They didn't really focus on the children adequately, or make plans that were designed to avoid probate, that would actually avoid the cost and length of probate. So I knew I had to get the word out when I learned about this new approach, and I became interested in special needs planning for kids because I have 2 children. 2 children of my 5 children have special needs. They have IEPs in school. This is Peter and Paul. I'm not going to tell you which one, but one of them needs special attention in school and in order to get things going on. He's going to have problems with work someday. But my kids really don't have the most serious symptoms. But my nephew has autism, and I've really seen the immense difficulties and worries that his parents have had in planning for their care. And it's something that I have a real heart for, because, parents are the number one advocate for their kids, but what happens when they're not there? I know it left me awake at night, and I'm sure it does with other people as well. Mm-hmm. I'll just talk briefly about why I got interested in estate planning. A few years ago, I had the opportunity to relocate and care for my parents in the last few years of life. And I saw the tragedy of my father previously working with a traditional estate planning attorney. By this time in their life, both my parents were special needs for different reasons. My dad was physically disabled. My mom was mentally disabled. And in the last few weeks before my dad died, he became more and more agitated instead of more at peace. Eventually, he asked me to look at his estate plan. My dad said he was still a little burned up because of the hourly billing that kept creeping up to more than double the original quoted price. He only met his lawyer one time, never followed up with things. I mean, I always provide my clients a flat fee. We meet at least 3 times to make sure everything is designed and as intended. But when I examined his estate plan, it was clear that it would fail in all the important ways. It was not going to avoid probate court, but the real problem is it didn't foresee or adjust to the changes in my parents' life. The plan nearly left my mother, who was living in a protected environment because she had advanced dementia, without care and with a threat of being pushed onto the streets. I thought it was malpractice at the time, but after talking and seeing how the traditional estate planning industry worked, I realized it was actually common practice. Fortunately, my dad allowed me to fix his estate plan, and before it was too late, we got everything signed and notarized the documents, and I felt a sense of relief. But my dad said he felt like was a hero for the first time in a long while, because he was able to protect my mother from a real disaster. This memory of a happy death really has inspired me to this day, especially as I think of all the other families who have suffered on multiple levels during this pandemic. So I want to help families be heroes for their family. And so that's why I love what I'm doing.
It's awesome.
Okay. Now what we're talking about is turning 18. It is a big deal. A lot of people recognize they have to sign up for selective services. And I'm not talking specifically about kids with special needs. This is everybody that turns 18, whether you're going to college or into the world. It's a major step in a child's life. And it contains responsibilities that many people, or you or your child, just might not be aware of or thinking about. Because once your child becomes 18, he or she becomes an adult. So for 18 years, your child was under your control as a parent. You took care of their finances, their health care, but now that they're an adult, it'll be solely your child's responsibility now. I mean, why is this a problem? I mean, it's a problem because even if you have a child that is ready for the world and is on top of his game, if that child gets injured in a serious motor vehicle accident, because they are an adult, you as a parent will no longer have automatic authority about handling their medical treatments or their financial matters. In fact, without proper legal documents, you wouldn't even be able to access your child's medical records or their financial records without a court order. So if you want to make sure that you can make decisions about your kid's medical condition or handle their financial matters in an emergency, you must have your sign 3 vital estate planning documents. All right, the first document, a medical power of attorney. This is a document that allows your child to grant you the immediate legal authority to make your healthcare decisions on their behalf if they become incapacitated or unable to make decisions for themselves. For example, the medical power of attorney will allow you to make a healthcare decision if your child is knocked unconscious in a car accident or falls into a coma because of a debilitating illness. If you have no medical power of attorney, if your child doesn't have it, you're going to have to petition the court to become the legal guardian, where you'll be able to make his or her medical decisions. This is a big endeavor. And as you can imagine, this can be a very slow and expensive process. And while it's true that parents usually are the court's first choice to be a guardian, it's not guaranteed that a parent will be chosen by the judge to be the guardian before the end of it. And because HIPAA laws, once your child turns 18, no one, not even a parent, is legally authorized to access an adult's medical records without prior explicit permission. But if you have a well-drafted medical power of attorney that includes signed authorizations, you can immediately access your adult child's medical records and make informed decisions about treatment. All right, the second document is a living will. So a medical power of attorney allows you to make healthcare decisions for your child once they're incapacitated. A living will is a document where your adult child states how long they want to be on life support until they want to be removed so they can be allowed to die naturally, or any other kind of special treatments they want to have. This way, the burden's not left ultimately on your shoulders. By having your adult child make these decisions on this matter, your family is never going to have to go through that long and costly family conflict that arose when Terry Shriver was stuck fighting over whether or not to remove Terry from life support. It avoids a lot of potential problems. Finally, you need to have a financial power of attorney for your child. If your adult child becomes incapacitated, you may lose the ability to access and manage their financial affairs. This requires your child to make you the financial power of attorney. This is a document that gives you the authority to manage their legal and financial matters, such as being able to make a deposit money into their bank account without you having to ask for their account numbers, or paying your child's bills out of your account, amongst other financial decisions you might have to make. And without this document, you may have to petition the court for such authority, which again will be very slow and very expensive. So in summary, if you want to make sure that you have the legal authority to help your child when they're over 18 with their health care and finances, especially in an emergency situation, you need to have them sign these three vital documents: a medical power of attorney, a living will, and a financial power of attorney.
You know, Michael, if I could jump in real quick.
Go ahead.
I just want to reemphasize the importance of this. Just in the last 5 years, we've personally, through SOAR, we've had two families who have had the tragedy of going through some medical emergencies with their newly adult children, and they did not have these in place. And it was absolute nightmares for them that I tried to help them and get them in place with. One was pre-COVID, one was during COVID. And both were absolute nightmares. Both of them ended up costing them thousands of dollars to try to get fixed. And like you said, the courts were not quick. And it really, really slowed things for them drastically with it. So this is one of the best things that we can be as parents, being advocate for our kids, is just getting this in place. We never know when something's going to happen. It could be a car accident. It could be anything. So it's just being prepared and taking care of that, because it's literally the day they turn 18, boom, they're considered an adult in the court of law and in the medical system. And you lose your right to tell them what to do or get that information unless you have all of this.
Yeah, these documents are something that every adult over 18 really should have. No matter whether your adult child has any special needs, it is something that weird things happen in life. I mean, we hear those stories all the time that something happens, and you can do a little thing up front and avoid a ton of problems. I can talk a little bit about special needs plan if that's good
Sure.
for you.
Sure. Yeah.
All right. Okay, let's talk about the reason why smart parents who love their children plan for what's going to eventually happen to every one of us. there's 10 steps that I recommend. I'm not sure we're going to get to all of them today, but first, here's a question that kept me awake at night before I had an estate plan. What would happen to your children if something happened to you?
Mm-hmm.
I mean, does anybody have any idea? I mean, most people don't realize this, and most attorneys don't realize this. But there are actually two time frames we need to think about when we consider what will happen to your children. There's the short term and immediate time frame and the long term time frame. Most traditional estate planners take care of the long term issue. It takes weeks to get that thing resolved. But almost no one takes care of the short term and immediate term. And frankly, that's very frightening for children, especially if there's a special needs child. And it's a big reason why I'm so excited about doing this modern method of estate planning, because we put that as a focus. When I discovered that the traditional estate plans were overlooking this critical component, I just knew I had to get the word out. So let's start there. On a practical level, think about what would happen in the short term if something happened to you. What would happen to your child with special needs if you did not come home? What would happen to your other children if you did not come home? What would happen to your most treasured belongings? In the short term, if your child is at home with a babysitter or a friend, or even at school, and something happened to you, the police will eventually locate your children. And if there's no clear person who has designated legal authority to stay with your children, police are going to have to call CPS to figure out what to do. And CPS must take your children into their custody until they can figure out what to do. I mean, think about it. If you leave your kids with a babysitter, you might leave the babysitter with your cell phone number, maybe your neighbor's phone number. But if something happens to you and you can't answer your cell phone, and if the neighbor doesn't have specific legally assigned authority to care for your children, the police would not risk liability by leaving your children with your neighbor's care or even your sitter's care for that matter. They have no choice but to call in CPS, really. And as a dad of 5 children, the thought of my children being taken into custody by authorities, cared for by strangers, even temporarily for a few weeks, nobody understanding what's going on, either my kids or the new foster parents, it scared me to no end because I had no plan. I just couldn't allow that to happen. So I set up planning documents right away with instructions for my kids if something were to happen to me and my wife. And I know you don't want that to happen either. So we'll talk about specific steps you can do in just a few moments. Before we talk about the specific steps you can take to ensure that your special needs kids are never going to be in that situation, even for a minute, let's talk briefly about the long-term care of your children should something happen to you. You should know that you already have a plan in place, even if you don't designate someone, but you're probably not going to like it. You're not going to like it because the plan requires a judge to decide your special needs child's future if you haven't already done so. This is expensive. It could take weeks to get a hearing. It's very public. Plus, the judge may decide to do something that's very different than what you would want to do. For example, as I mentioned, I have 5 children. 2 of them are still minors, and I know exactly who I'd want to raise them if I couldn't. But let me tell you what probably would happen if I didn't legally designate that person. 2 people would probably come forward to raise my children if something happened to me and their mother. My brother and my 20-year-old daughter. My brother's 40 years old, lives in South Carolina. He's married, very successful financially as a financial advisor and airline pilot. He has 2 kids. My daughter's in college, is not married, never had kids, still goes out at night sometimes with her friends, and doesn't have a lot of extra money. Now, you'd be the judge. You heard the facts of these 2 people. Who would you choose to raise my children? I mean, the obvious choice is my brother. That's what a judge would be looking, what's on paper. But it'd be wrong. He would look really good on paper, but he's the last person in the world that I would want to raise my children because his worldview is so very different than mine, and his complete lack of, empathy for anyone. That's not going to be on the paper. The last person in the world that I'd want raising my kids would be my brother, but it's not because I don't love him. I do. Because in my heart, I just know he would not parent my children the way I would want. Whereas I know my daughter would, despite her circumstances. She would not look good on paper, but she's very loving and would be great at raising her brothers because they know of her. And a court would never really be able to adequately judge that. And the worst case scenario, my brother and daughter could be fight about it and about the court's decision. And the kids could end up in foster care even longer. A worst case scenario, certainly, but it's one that's not necessary to risk. So it's really to avoid this scenario with what I call a child protection plan. And I'll talk a little bit about that in a few minutes. But before we talk about what you can do to ensure that you have a child protection plan, let's talk about how your special needs child will receive your assets. Before he or she gets access to their inheritance, the money is going to be spent on the probate process, possibly on estate tax, and probably creditors before they see a penny. And if you have a will that has to go through probate, by definition, it's going to have to go through that probate process before it gets passed on to your heir. Some people define will as a lawsuit that you file against yourself with your own money for the benefit of your creditors. Your special needs children, and other children will be the last ones to benefit for whatever's left if you decide to go through probate. And you also need to think about what your special needs child will do with an outright distribution of cash that's unguided and unearned. The cost of going through probate is very expensive. Okay, so let's quickly calculate your estimated probate estate. If you have a sheet of paper in front of you, you can calculate your estimated probate cost too. If you have a family home with a fair market value of $400,000, stocks, bonds, bank accounts, let's say it's $150,000. Life insurance for $450,000 that's left to your estate. The total is $1 million. I mean, if it's going to your spouse, that makes sense. If it's going to a child, you really need to think about, maybe we should think about things a little bit more detailed. But if that $1 million estate, you multiply it times 5%, and becomes up the gross estate for costs and fees, and it'd be about $50,000. That's a lot of money that is just being wasted away into the system. And you can prevent that from being spent simply by a little bit of planning ahead of time. The good news is probate is totally voluntary. The only people who have to experience it are those who don't plan. Finally, and worst of all, your children would be entitled to all your assets outright without any restriction on it at 18 years old. My son's best friend received about $400,000 when he was 18. He was very smart. He had no special needs at the time, but the first thing he did was buy that fancy red sports car, and the rest he spent on experimenting with exotic drugs provided by his brand new friends. As a result, he didn't graduate from college. He acquired a special needs with some diminished mental faculties, and he's stuck in a low-skilled part-time job. He has a lot of trouble supporting himself financially, and because he's entitled to another large distribution in a few years, he's not eligible for government benefits that would have helped him. And if you don't think your special needs child will ever need government benefits, if you give your child an outright inheritance, there are many benefits that are tied to remaining eligible. So the key is 10 steps for a special needs plan. By talking about these 10 steps, you'll have the peace of mind knowing that your child will be protected if anything happens to you. I'm not sure we're going to get through all these 10 points, but we'll give it a shot, okay? Sure. Step 1. If you have children under age 18, you must give clear legal authority for your designated caregivers to take custody of your children immediately if there's an emergency. So have you named short-term guardians? You need to tell your children or the caregivers exactly who they should call if something happens to you. You must make sure that the person who is called has legal authority to stay with your children. It's not going to do any good to have a neighbor or friend come over unless they have documented legal authority from you to stay with your children. Make sure that they've been given documented with clear legal authority to one or more people. I prefer 3 people who live near your family and would be able to immediately come to your children. I usually recommend you choose people within 20 minutes of your home. These people should be people who would be able to comfort your children during a crisis in the short term. Far too often, we've seen people name guardians to act and not tell them that they've been named or what to do if something happens. Don't make that mistake. Make sure the people that you've given legal authority to know that they're going to be called on if something happens to you. And make sure they know just what they should do in that situation. The person or per people that you give legal authority to stay with your children must have all the documentation they need if necessary. Remember, this is just for the short term until the long-term guardian arrives. This is important. I think I went too far. This is important because, Imagine a police officer arrives at your house after an accident. The babysitter's with your kids, and it'll take many hours or even days or even weeks for the long-term guardian to arrive. The police officer can't leave your children alone with the babysitter or neighbor because they'd be subjecting the state to liability. So the officer will have to remove your children from your home. And of course, if your babysitter or someone can't prove they have clear legal authority to stay with your children, the police are going to have cannot leave your children in your home until the people you named as a guardian can arrive. So if you decide what would happen, but you only told people you don't have the legal documentation for them, it's a recipe for disaster. Now, if your child has special needs, you need to address the long-term guardianship issue head on, especially if you have other children. I mean, do you want your children to live together? Or would your typical children have one guardian while your child with special needs has another guardian? We know these are difficult issues to address, but now is the time to make a decision rather than leaving it up to chance. It's important that this designation is properly made. Many times we'll hear people say like, well, I want my brother Tom and sister-in-law Jane. But when I investigate a little bit and I say, will you really want Tom and Jane? What if Tom died or Tom and Jane got divorced? I mean, you don't really want Jane, or you really wanted just Tom. So you make sure you think through all the possibilities before documenting your choices. Okay, step 2.
Real quick, Michael, I've got a question that came in since we were just talking on guardianship, if I can jump in with it.
Mm-hmm.
Question that came in, kind of combining the guardianship here and going back to your very first point about the, everything with the 3 papers they need to sign. Does guardianship eliminate the need for, the medical power of attorney and all that other stuff, and how does guardianship play into that when it comes to making those decisions?
If you have a guardianship already taken care of, you need to make sure that there is, well, first of all, successor guardians if something happened to somebody. When they turn 18, you need to get that updated. It's not automatically going to be continuing on. Okay. All right, step 2. Once you've named the guardians of your children, you identify whether you need future care planning for your child. If your child is an adult with disabilities, you probably have a pretty good idea of both your child's abilities and what kind of assistance they'll need. If your child is able to support themselves, including housing, health, insurance, and basic needs, you might still need to consider future care planning, but on a more limited scale. On the other hand, if your child won't be able to be self-sufficient as an adult, you'll need to make plans to secure their future. Leaving the future up to chance is really not an option. Without a plan, it's possible your child will join the ranks of millions of people in this country with disabilities who live in poverty. On the other hand, if your child is particularly young, you might not yet have an idea of whether your child will be self-sufficient as an adult. You want to be hopeful, but you know that there's a possibility that your child will need assistance. Planning, even though your child's future abilities are uncertain, will give you the most comfort and the best options. You must make the hard decisions now, even if you feel uncertain whether your child will need assistance as an adult. With the guidance of a trusted advisor, you'll be able to build a what if scenario and contingencies. Step 3. When your child reaches 18, you will no longer be entitled to make decisions about your child's finances or personal care unless you petition a judge to become your child's legal guardian. The law presumes at age 18 that your child is capable. If your child enters the hospital after they turn 18 and medical decisions need to be made for him, the child's doctor will ask you to show guardianship papers before treating your child. Guardianship is a legal means of protecting a person who is not competent to make decisions about their personal care or finances. Because a full guardianship takes away your child's rights to make important decisions, the decision to petition guardianship of your child at age 18 should not be automatic. If your child is capable of making some decisions but not others, a limited guardianship may be more appropriate. We can just look into the world of pop stars and recognize how this can be abused. Likewise, there are certain alternatives to guardianship that may be sufficient. If your child has the ability to make their own decisions, went too far. If your child has the ability to make their own decisions, they can empower you to make the healthcare and financial decisions by signing financial and healthcare powers of attorney. Likewise, if your child receives Social Security payments, you can be the designated representative payee. A joint bank account or trust might also serve as a means of providing structure and discipline to a monthly budget. Step 4. Your child will be eligible for government benefits at age 18, but you must prepare to preserve much needed benefits. There are 4 main programs available for adults with special needs. There's Medicare, Social Security, disability insurance, Medicaid, and supplemental security incomes, SSI. Medicaid and Medicare provide health insurance. SSI and SSDI provide monthly cash assistance. Medicaid recipients are also eligible to participate in the so-called medical waiver program, which provides supported housing and work programs. Which programs your child will qualify as an adult and how much they're going to receive as way of benefits depends on whether your child has a work record or other assets or income. A child who has a disability determination and a work record who has parents with a work record can often receive Medicare and SSDI in addition to Medicaid and SSI. Of course, SSDI will often cancel out the SSI benefits, but there's no need to do special planning just to preserve Medicare or SSDI because these are not resource dependent. Many disabled adults, however, rely on Medicaid and SSI support or rely on these programs in addition to Medicare and SSDI. To qualify, Medicaid and SSI must meet certain income and asset limits. If your child has more than $2,000 in their name at 18, they're not going to qualify. It's crucial to do the special planning for any child who's likely to receive these benefits because if your child has more than $2,000 in their own name at 18, they're not going to be eligible for benefits until they spend down that money. All right, step 5. You need to develop an understanding of what the future care of your child will cost and what your best options are for meeting your child's needs. So many times we talk with parents who have placed their adult children in a particular facility because they don't know that they have other options. A life care plan can ensure that your child receives appropriate care, whether at home or a residential facility, identify public or private sources of support, give you the peace of mind of knowing that you are making the best care choices for your child. There are professionals in the community who can assess your child's needs, make recommendations, use them. You get the support that you need. Step 6, make the transition of your financial wealth as easy as possible for your family. Without an estate plan in place, your loved ones won't inherit the money in the way that you want. In particular, any inheritance that your child receives will likely disqualify them from government benefits. It doesn't have to happen. Further, your financial assets may be subject to a court process called probate. Probate process is public. It can take a long time. Plus, your loved ones won't have immediate and protected access to your money. There are numerous court costs and filing fees. On the other hand, if you plan with a revocable living trust, in addition to your will, you decide who has access to the information about your child's inheritance. This protects your child and other family members who may be serving as trustees. If your financial resources pass to your spouse and children by a will, the information becomes part of the public record and is available to predators who might be particularly attracted to vulnerable beneficiaries, such as the young and disabled. Because none of us know when we might die or become incapacitated, it's important to plan early for your child with special needs, just as you would your other dependents, such as minor children. Unlike most beneficiaries, your child with special needs will never be able to compensate for your family's failure to plan. A typically developing child can work, support themselves as they reach adulthood, but many children with special needs may not have this opportunity. Planning for your child with special needs is only one part of putting together a comprehensive estate planning to protect yourself and your loved ones. And there are options. I like to work with insurance people who will be able to help if those things happen at the wrong time. So, are you concerned about the potential incapacity of your spouse? I mean, there's solutions. What about your typical children? Do you want to provide for them as well? Make sure that your estate plan provides for and protects for all the people that you love. Doing so ensures you and leaves a positive legacy for your entire family. Plus, don't make the mistake of thinking that a trust is something that you can do once and then never think about or look at it again. If you're going to do that, you might as well not. A trust is something that must be updated and maintained throughout your lifetime, so it keeps up with your life, your assets, and the law. And after your death, it must be handled properly in order for it to work. All right, how are we doing on time?
We got about another 10 minutes.
All right. All right. So step 7. If your child requires or is likely to require governmental assistance to meet their basic needs, do not leave money directly to your child. Instead, establish a special needs trust. A trust that is not designated with your child's special needs in mind will probably render your child ineligible for essential benefits. A special needs trust is designed to manage resources while maintaining the individual's eligibility for government benefits. Planning is important because many beneficiaries as adults will rely on the government benefits for support. And if the disabled person has assets in their own name, the current limit's $2,000, they might lose eligibility. Medicaid and other public benefits will not pay for everything that your child might need or want. A special needs trust can pay for medical and dental expenses, annual independent checkups necessary, desired equipment, such as a specially equipped van, training, education, insurance, transportation, special foods. Unfortunately, some special needs trusts are unnecessarily restrictive and generic. Many trusts are not customized to the particular child's needs. Thus, the child fails to receive the support and benefits that the parent provided when they were alive. For example, children who are high functioning and active in their communities can benefit from a special needs trust that is carefully tailored to provide adequate resources to support their social lives. Does your child have significant medical concerns? Should the trust allow for birthday gifts or other family members? What about travel expenses to visit loved ones? Do you have a preferred living arrangement for your child? Your child's special needs trust should address all those issues and more. Another mistake attorneys with special knowledge in this area often see a payback provision in the trust rather than allowing the remainder of the trust to go to others upon the death of the child with special needs. If a payback provision is included, unnecessary Medicaid will receive the remainder up to the amount of benefits provided in the trust upon the death of the beneficiary. These payback provisions are necessary in certain types of special needs trusts. An attorney who knows the difference can save your family a small fortune. A special needs trust will help you avoid one of the most common mistakes that parents make. Although many people with disabilities rely on SSI, Medicaid, and other needs-based benefits, you may have been advised to disinherit your child with most disabilities. The child who needs your help the most to protect the child's benefits. These benefits, however, rarely provide more than subsistence, and the solution will not allow you to help your child after you're incapacitated and gone. So disinheriting your child with special needs might be a temporary solution if your other children are financially secure and have money to spare, but disinheriting your child with special needs is a mistake. It's not a solution that will protect your child after your spouse is gone. And that money can be lost in a lawsuit or divorce or liability claim or an adverse judgment against your children. For example, what happens if your child with the money divorces? Or his or her spouse might be entitled to half of it, and likely you will not care if your child with special needs. What if your child with the money dies or becomes incapacitated while your child with special needs is still living? With his or her heirs, will his or her heirs care for your child with special needs? Are you aware of the different types of special needs? There are basically three types. There's a third-party trust, the self-settled trust, that's a first-party trust, and then there's a pooled trust. All three name the person with special needs as the beneficiary. A self-settled special needs trust holds assets that belong to the person with special needs, such as an inheritance or an accident settlement. A third-party trust, special needs trust, holds funds belonging to other people who want to help the person with special needs. A pooled trust holds funds for many different beneficiaries of special needs. The reason that there are 3 different types of trust has to do with the regulations regarding supplemental security income. SSI is a government program that assists people with low income who have special needs. In order to qualify for SSI, an applicant or beneficiary can only have $2,000 in his own name. If the person has more than $2,000 in his own name, the government allows him to qualify for SSI, so as long as he places his assets into a first-party special needs trust. While the beneficiary is living, the funds in the trust are used for his benefit, and when he dies, any assets remaining in the trust are used to reimburse the government for the cost of the medical care. These trusts are especially useful for beneficiaries who are receiving SSI and come into a large amount of money because the trust allows the beneficiary to retain his benefits while still being able to use his own funds when necessary. The third-party special needs trust is most often used by parents and other family members to assist a person with special needs. These trusts can hold any kind of asset imaginable belonging to the family member or other individual, including a house, stocks, bonds, intellectual property, other types of investments. The third-party trust is like a self-settled special needs trust in that the assets held in the trust do not affect an SSI beneficiary access to benefits, and the funds can be used to pay the beneficiary supplemental needs beyond those covered by the government benefits. But a third-party special needs trust does not contain a payback provision found in the self-settled trusts. This means that when the beneficiary with special needs dies, any funds remaining in his or her trust can pass to other family members or to a charity without having to be used to reimburse the government. A pooled trust is an alternative to the self-settled special needs trust. Essentially, a charity sets up these trusts that allow the beneficiaries to pool their resources for investment purposes while still maintaining separate accounts for each beneficiary's needs. When the beneficiary dies, the funds remaining in her account reimburse the government for her care, but a portion goes towards the nonprofit organization responsible for managing the trust. Of course, every person with a special needs is different, which means that every special needs trust is going to be different as well. You can't do a cookie cutter approach. The only way to determine which special needs trust is right for your family is to meet with a qualified personal, family, and legacy lawyer to discuss your needs. So I think we only have about 5 minutes right now. So are there any questions that we want to talk about?
Yeah, I don't have any that have come in right now. So yeah, probably just finish up this one on the special needs trusts, and then we'll tie everything up.
All righty. Yeah, just looking at some of the chats. Okay. So the coolest thing about working with a lawyer who knows about this is you can make a living trust into a real treasure chest for the benefit of all your kids. You can opt to protect what you leave to your kids so it can never be taken away by a spouse in a divorce, or even touched if your child's in a car accident or some point in the future. You can give your children the gift of airtight asset protection for what you leave behind, something that they'd never be able to give themselves. All right, step 8, you need to build a team. During your life, you can manage the trust, but when you and your spouse are no longer able to serve as a trustee, you can choose who will serve according to the instructions that you have provided. You may choose a team of advisors, and you get to choose who would be the professional trustee. Regardless, the trustee's primary duty is to protect the trust beneficiary's eligibility for public assistance benefits. Make sure that whoever does this is financially savvy, well organized, and most importantly, ethical. By default, family members of the beneficiary are often appointed as the trustee. All too often, however, family members acting alone often lack the skills needed to successfully administer a special needs trust. So they should consider a professional trustee in conjunction with an advisory committee or an advocate care manager or a trust protector. If not, there are other ways to incorporate professional expertise into the administration of a trust. So the right trustee is going to provide the trust beneficiary and their families with the peace of mind that comes from knowing that the public assistance will be protected and that quality of life will be increased. The right trust protector can break up disputes and have other duties that might include modifying the trust that trustees can't do. And I'm just going to go quickly over the last two steps. Step 9, guys, you have to provide enough financial resources. It's your responsibility. Insurance can be a major help in helping your special needs kids. So do you have a special needs financial plan? So you need to work with a team to make sure that you have the right plan, the right type of insurance. You should consider purchasing permanent insurance rather than just term insurance. That's going to go away and get more expensive. But the decision of how much is very important. Have you considered inflation, taxes, life insurance? Step 10, it's important to pass on more than just money. Your legacy is more than documents. It's more than just cash. You need to realize that you've spent a lifetime caring for your children. You have a lot of knowledge and experiences. Be sure to write a record or a complete set of instructions to guide future caregivers and trustees as they take care of their children, your children. Include information regarding their residential preferences, medical condition, their preferred doctors, therapists, essential therapies, social activities. And although such instructions are not legally binding, they can reflect your thinking on a range of issues and provide a plan for caregivers to follow. We always try to record your human, intellectual, and spiritual values as part of our plans. That includes your most cherished memories, your love and so they can see your love when you're no longer with them. And so you have to think about how will your child remember you. Key point, you don't have to do this alone. You have two options. You can do it yourself. You can work with an attorney who knows and can help your child.
So we've got a couple of questions I want to just address real quick, and we'll tie everything up here real quick. There was one comment, one of our attendees said, she had been delaying doing any of this about getting, all the paperwork, the medical power of attorney and all that, and doing all these steps because of the cost and the fear of it. But she's heard enough horror stories, gone ahead and done that. And that's what I would say, guys. The cost of doing it now before something happens is always going to be much cheaper than in the case of emergency when you need it and get the courts involved. It's, and Michael, you can speak to that more than I can, but what I've seen, it's usually in the emergency situation, it's usually my experience with the two families I've helped, it's been 5 times the price of what it would have been if they did it ahead of time.
Yeah, it'd be under $1,000, for me, for those basic plans. And I'm flexible because I think it's important for every 18-year-old to have those basic documents.
Yeah. And then there's 2 other quick questions. We'll just tie everything up with. First question is, who might serve as a trust protector? Does it always need to be an attorney?
No, it doesn't have to be an attorney. It can be anybody that you sort of trust. Somebody who's objective, somebody that can listen to both sides and come to a resolution. There's a lot of powers you may give or not give to the trust protector, but that's part of a longer conversation.
Okay. And then the last question we got, and we may not have time to get into all of it, but the question is, how about DPOAs versus guardianship at 18? I'm not sure what the
DPOA is, a durable power of attorney.
Okay, perfect.
Versus a guardianship. If you have a guardianship at 18, it probably includes the powers that's in a durable power of attorney. I'd have to look at the document, but generally that's going to cover that if it's ongoing. But again, every child is different, and you have to sort of think about, is everything really covered? If something happened to you, is things going to be smooth for the next week with your kids? Because in my case, in my experience, nobody's really thinking about that.
Yeah. Okay. Well, fantastic. This has been a wonderful, a lot of great questions, a lot of great things to chew on. Again, Michael's contact is on here, michael@kclegacylaw.com. Make sure you reach out to him. One of the things he said in all this, and I cannot emphasize this enough, when you go out trying to get a special needs trust, trying to do all these things, you want to have an attorney who understands special needs trusts and who deals with this. So just don't go to anybody. Make sure you find somebody. You can come to me. We've got several attorneys who work with them, and Michael's definitely one that we would recommend here. I got several announcements just want to share with before we leave. First, I should have done it at the top of the hour, but I need to make sure I say it now. Happy World Cerebral Palsy Day to all of our amazing families and friends with cerebral palsy. We love you. We're so excited about you and love working with you. We want to honor you today. This is every day should be your day, but today we specifically are recognizing you, and we just want to tip our hat to all of our friends with cerebral palsy as well as their families, and let you know how much we love you, and we're here to support you all the way. Second thing, especially to all of our listeners in the Kansas City area, help us tomorrow, October the 2nd. Go get frozen yogurt at Yogurtini. The Yogurtini at 135th between Antioch and Schweitzer. Fundraiser from 11 a.m. to 11 p.m. Tell them you're with SOAR Special Needs, and 20% comes back to us. So that's going to be a great way where we can help continue to transform the lives of our amazing families. And you can fill your tummy with wonderful frozen yogurt. It's healthy, it's fun, it's going to be a great way, and it should be a beautiful day tomorrow. So take your family out and do that. We'd love you to do that. And the other thing I'm super excited to announce, if you haven't seen it yet, we just launched a brand new website. SOARSpecialNeeds.org just launched brand new today. So go see it. If you're having trouble get to it, go and clear your browser history, clear your cookies, because it might be trying to go to our old one and can't find it. So make sure you clear everything so you can find that. But new look, and let us know what you think. It's going to be a lot easier for you to navigate and get around. Our next Talk with Doc will be in a couple of weeks. Actually, we're taking the month of October off because of the conference, and I'm gone to several conferences here. But the next one will actually be coming up November the 12th. And it's one that really is going to be important for all of our families with disabilities to attend. That one is going to be on dealing with those who don't deal with disability. So especially when we're with our family coming up on the holidays who don't understand disability and what to do with it. David Glover is going to be joining me, and how we can help others understand disability and how we can talk through that. So you'll want to make sure you're attend with us there for that. November the 12th will be that one. It'll be a great talk. And again, we'd love to have you continue to partner with us. As always, if you want to help us financially be able to continue these types of talks, you can go to soarspecialneeds.org/donate and participate there. But again, Michael, want to thank you so much for joining us here today and just helping us with this. It's been a very good talk and very insightful. And again, why don't you just share again how people can get in contact with you?
Right. You can email me at michael@caseylegacylaw.com. Or if you'd like to call, I'd be happy to give you a 15-minute consult. You can call 913-228-3144. 913-228-3144.
Wonderful.
Thank you all for listening.
Yeah, and thanks for coming out, guys. And please don't delay in doing this until it's too late. Be proactive. Be ready for when your child turns 18. And that's the best thing we can do in taking care of our kids. So hope you all have a great day. Come soar with us. Bye-bye.